Good evening, people. I'm actually shooting the first part of this video. This is actually the second video which I'm shooting is the first part of the argument which I made the because I had already shot it, but somehow it got destroyed. I lost the evidence. I'm so sad. So I have to actually go ahead and recount everything which I said in the first part and shoot it again. Firstly, my apologies because I know many of you are watching the second video first, or maybe who will watch the second part of my critical analysis of the Shahbagan County Judge's decision to overturn Steven Avery's plea for a retrial. Um, you will see a horrible background. Please close your eyes and just listen to my words. And just a few words for Dark Side of the Moon. Thank you, buddy. Thank you, mate. Your words encourage me a lot, and that is the reason why actually I'm going ahead and making these videos, just to make you all aware that what's happening in this case, what are the legal principles which are getting uh, uh, like which are getting hampered, which are not being taken notice of, they're not taking cognizance of. And I would just like to point those things out so that you all are well aware, you know the law, and in case ever you have to face a judge in a courtroom or anything, remember, if you have a sound logic, justice follows that. Okay? So, justice, I believe, is something which is always backed by sound logic. So, you try and understand that sound logic behind the law, and it will serve you. So, before we go ahead and I just go ahead and start with why I believe the Sheboygan County judge has erred in applying certain principles of law which she herself stated, which she herself has introduced in her judgment or her decision, but she hasn't followed it through. Okay, and how she has misapplied one test, which I feel has brought about this kind of a confusion, and Stephen Avery has been denied a retrial. Okay, personally speaking, I feel right now what is happening with the Wisconsin state is like, if they go ahead and admit this, then they are essentially admitting the wrongdoing of their police personnel there, and that would result in a major fallout. And that is the reason why they are doing anything they can to go ahead and muddle things up still. And if that happens, the whole state machinery falls. You're talking about the judiciary and the executive, both these machineries, they fall. And if that happens in a state, it can actually lead to a lot of, I would say, anarchy. But I would say, if you are doing it at the cost of keeping an innocent man in jail, that's not worth it. You own up, and you say that you're wrong, right? So, firstly, I'm just going to go ahead and state certain principles of law and exactly what they have stated in this case. So, we all know what the facts of the case are. I will still repeat it a little later. Now, for the affidavit of Sovinsky to be admitted as evidence establishing Bobby Dassey as a valid third-party suspect in the murder of Mrs. Hallback, the defendant must satisfy two separate tests. This is what the judge is saying. The test in Denny, first is test in Denny, requires the defendant to show that the third party had a legitimate tendency to commit the crime at issue. To meet this burden, the defendant must show that a third party had the motive to commit the crime. Number one, motive to commit the crime, the opportunity to commit the crime, and there is some direct evidence linking that party to the crime that is not remote in time, place, or circumstances. Okay, so these are the three tests. It's difficult to prove the Denny test without any DNA or blood evidence, without the fact playing on our minds that yes, the state agency is a player here. Okay, so it would serve their interests better if they convict Stephen Avery instead of Bobby Dassey. So you cannot go ahead and apply the Denny test impartially, absolutely neutrally, without these factors taken into consideration. So, in my opinion, the Denny test should not be applied in this case at all. The primary reason being, the state police is a party in this whole matter. And the moment that happens, it is very difficult to show or prove that a very impartial investigation has happened due to which Steven Avery has been pronounced guilty. Okay. Now, some people might say, "How can you say that?" Right? You cannot say that, right? Like, because the state it's police. We have to trust someone. Absolutely, you need to trust the police. But if the police is facing a lawsuit which is over $40 million, and they are, that would probably leave them bankrupt. What serves their purpose better? Convicting Bobby Daisy or convicting Steven Avery? Probably the former is better, right? Because you can get out of a sticky situation, and the moment you do that, they can actually use it as a leverage. Because the moment Steven Avery was sent in jail, the huge multi-million-dollar lawsuit, it was brought down to $40,000 because he couldn't afford his lawyers, so he needed that money. So they settled for a far less amount. The moment Steven Avery was arrested and put in jail, and a lot of other things happened because of that. So that was the reason why the state agency, the moment you put them as a party in all these proceedings, it's very difficult to satisfy the Denny test, because they could be in cahoots with the real accused, and they will probably help him so that they could actually go for the other suspect, which would serve their interest better. Now again, am I saying that they did it? No. But what am I trying to state? I'm trying to state is there's a probability of that happening, right? And if the probability is very strong, that should be taken cognizance of. There is one more point to it. We can show directly through evidence that when it came to the discovery of certain critical, crucial evidence, like the key in the trailer park, who did it? It was the state police. But we have to go a little back, right? How did they discover the key? They were not supposed to be in the crime scene. So first look at the premise. The premise is there are two Calumet deputies or police personnel, and they are there to do their job. And you know what their job is? Their job is not just to scan the crime scene to find evidence. Their job is to also keep an eye on the Manitoba County Department people who are also present in the crime scene. Now what happens after that? They discover the evidence. They discover the key. Now when this happens, you have to also take into account the premise that something fishy could have also happened. You can't do that if you're saying that no, we are giving everything to the Calumet County. There's a conflict of interest. You're absolutely right. Great. You did it. But the conflict of interest happens the moment you enter the crime scene. It doesn't happen when you discover the key. It happens the moment you enter the crime scene, and the moment two other deputies have to keep an eye on you and also try and scan the area for evidence. And they have clearly stated that they searched that area earlier, but the key didn't catch their eye. So how did it catch his eye? So we have a kind of a situation which has emanated from completely a completely wrong way of approaching a crime scene when there's a party in conflict of interest. So the moment that happens, the moment the Manitoba County Department Police enter the crime scene, they have established conflict of interest, because we don't know what they are going to do next from there. And the discovery of the key is a reasonable, probable conclusion or an effect of what could happen. So we don't need to get into, no, they found the keys, really it was there only, it was behind the shelf, the door came out and then it fell down. So they discovered it by accident. It was a good act on their part. They did not plant the key. That is not even required to be proven, because already conflict of interest has been established the moment Manitoba County sheriffs have entered that crime scene where they were not supposed to be. and they enter and they prevent the Manitoba County coroner from entering and doing a complete analysis of the bones and everything, which could have actually helped in the investigation, whereas she was not even in any kind of conflict of interest with Steven Avery, because she did not do anything with the Steven Avery prosecution when he was convicted of a crime which he was innocent of. But she was prevented. But these people, they can go into the crime scene and they can discover keys of the RAV4, right? So we we have to understand this proposition, because the moment you see that these three elements of law, which is the Denny test, that to meet this burden of the defendant must show that the third party had a motive to commit the crime, the opportunity to commit the crime, and there is some direct evidence linking that party to the crime, is not remote in time, place, or circumstances. Who are going to go ahead and find these things? The police. And you are not sure whether the police is in cahoots with the Bobby Daisy, or they are really doing their job or not. So applying the Denny test is very dangerous and risky in this kind of a position, which the judge uses, which is not right. We don't even need to go into the computer and 5 people are looking into that computer, or we don't even need to look into the motive, nothing of that sort, because already there's conflict of interest, right? Now let's look into these elements still, just to be on the safe side. Let's look into these elements. Motive to commit the crime. The motive to commit the crime, what they have established is it's Bobby Daisey's computer. In Bobby Daisey's computer, there are certain pictures, objectionable pictures, which have been found, which go to show that yes, he might have some sort of deviant interest, which could prove that yes, he could have committed the crime, right? Now what the judge says is anybody could have had access to the computer and they could have done these searches, so you cannot go ahead and convict Bobby Daisey about it, right? Now, personally speaking, we all know that is just a way of diverting our attention. We all know that it's Bobby Daisey's searches and he was there who did the searches, and I believe there must be even a testimony of Bobby Daisey with Fassbender and everything where he admits this, which is not even in public records. But fine, let us keep that presupposition aside and say that this is a really mothball theory, because usually the only person who used to frequent that computer, as per the family testimony and everything, it was Bobby Daisey and no one else, right? Did he have the motive to commit the crime? Yes, he definitely, because he must have seen Teresa Hallback and he felt some sort of an urge which propelled him to go ahead and commit this crime. The opportunity to commit the crime, yes, he did have the opportunity to commit the crime, because if you accept the fact that he was the last person, he was the person who saw Teresa Hallback last with Steven Avery, then definitely he's also the last person who can actually go ahead and commit some sort of a mischief with respect to Teresa Hallback. So he does have the opportunity, okay? And that is by Bobby Daisey's word, nobody else's word, because he saw her last. So if he saw her last, he definitely has the opportunity, because after that we really don't know what happened. We can either rely on Bobby Daisey's testimony, Brendan Daisey's testimony, or Steven Avery's testimony, but we don't know what happened. So if he was the last person to see her, he does have the opportunity to commit a crime. The fact is, he has the opportunity, right? We don't need to look into whether that opportunity is remote or less or anything. He has a very strong opportunity to commit some sort of mischief. Now, there is some direct evidence linking that party to the crime that is not remote in time, place, or circumstances. Definitely there is. Sovinsky has seen him riding that RAV4 with an older person in the morning of 5th November. What else do you want? That is a direct evidence. Now, of course, you can go into the credibility of Sovinsky's testimony, question him, cross-examine him, find out why he said that. Go into that. But for that, you need an evidentiary hearing, which you are not giving. So it doesn't work out that way. So even if we look at the Denny test, just by stating that the motive is not there, the computer, everybody can access it, that does not go ahead and absolve the Denny test. So the Denny test in itself, if you still look at it closely, it still gets satisfied somewhat. I wouldn't say that it gets satisfied completely, but it does get satisfied somewhat. The problem is we do not have major blood or DNA evidence which links Bobby Daisy to the crime. But we have a major evidence, and that is a witness testimony which says that he was riding the car, he was pushing the car. I'll be stating exactly what he was doing, and that was seen by Mr. Sovinsky. So that is a direct evidence which should be examined. The point here is which should be examined. You cannot just throw it out, because the moment you're throwing it out, you are throwing out the fact. You are stating that Sovinsky is not a credible witness. You've not proven that. You've not shown that. In my opinion, he's a credible witness because he has followed up time and again. He's persistent. He's tried to go ahead and present his version of facts. He's come across as a very good citizen who's tried to present his version of facts despite the state trying to shroud it and hide it away from Steven Avery's defense lawyers. So, in my opinion, he is a very credible witness. So, that is what needs to be satisfied here, not the fact that the computer which was accessed by 5 other people or something like that. Okay, that is just a way to distract everybody so that somehow you can shoehorn the Denny test. It doesn't work that way. Okay, so now the second part of the argument. Now this is the analysis part, which I'll again say this is in page 5 of 31. The defendant also raises and correctly identifies that the test set forth in State versus Edmund also applies to the admissibility of the affidavit itself. The Edmunds test establishes a 4-part test to determine if evidence is newly discovered and admissible for consideration by the court. Now, in order to do that, whether a retrial will happen or not, there are 4 tests. And actually, the Edmunds test completely satisfies all the criteria which are required by Steven Avery to get a retrial. But what happens? What is the problem? I'll even tell you that. Okay. First, the evidence must have been discovered by the defendant after the defendant's conviction. It has happened here because Sovinsky had gone ahead and reported this incident, but the police did not take any notice of it. He went ahead and reported to the Innocence Project. They also could not forward the case. Later on, this came in the hands of the defense lawyers of Steven Avery. That was well after the conviction. So this is simple. This test gets satisfied and the judge has acknowledged it. Second, the defendant must establish that he was not negligent in seeking out the evidence in question. How can they be negligent? Because this evidence was in the state police in the first point, but they did not go ahead and disclose it. Thankfully, the telephone operator who took the call actually filed this under the public record, and we could find it, and that's the reason why we know that he has actually gone ahead and reported this incident to the police as soon as it happened. But the police did not acknowledge it. Police said, no, we know that Steven Avery is guilty and we will do everything in our power to prove his guilt. Nothing else. So, this is very clearly, it can be seen that there is a design on the part of the state police that they wouldn't like to see any other person being put forward as a murder suspect. Only 2 things can happen in this case. Either the police are in cahoots with the real murderer and they have framed Steven Avery, or the second point is they are so blind that they say, no, I don't care, I will just go ahead and pronounce Steven Avery guilty because I can save my skin, I will be free, I don't have to pay $40 million. Okay, so only these 2 things could have occurred, right? So even the second test gets satisfied. The defendant must establish that he was not negligent in seeking out the evidence in question. There is no negligence on the part of Steven Avery or his defense lawyers to find this evidence because it just didn't come into their hands. There were numerous agencies within who were negligent, who did not go ahead and do their duties, because of which this did not happen. Third, the defendant must establish that the evidence is material to an issue in the case. Fourth and finally, the defendant must prove that the evidence offered is not merely cumulative to that already in the court record. Okay. Now, the point here is the evidence is material to an issue in the case that I have gone ahead and explained in my second video, which you will be hearing after the first video is over. And the evidence offered is not merely cumulative to that already in the court record. It's basically, it is just not flowing from whatever has been found before. It's just the effects of that. So it is not merely cumulative to that. Now I will go ahead and clearly just go ahead with the version of facts of Steven Mr. Sovinsky, so that you all know and understand what exactly happened here. What is the testimony of Mr. Sovinsky? In his affidavit, Mr. Sovinsky states that in the early morning of November 5, 2005, he was delivering newspapers to the Avery salvage yard in the course of his employment. Prior to actually delivering the newspapers, Mr. Sovinsky states that he encountered Bobby Daisy and an older unidentified man pushing a dark blue RAV4 down Avery Road towards the junkyard. That means the place where the car was found. Very important. Number one, identification of the car. The car is a RAV4, dark blue RAV4, which belonged to Teresa Hallback. Secondly, they are pushing it in a direction where finally it was found by the search party member, right? Mr. Sovinsky states that the car did not have its lights on. After delivering the newspapers to the Avery mailboxes, Mr. Sovinsky states that he drove towards the exit where Bobby, the older gentleman, and the car still were. Mr. Sovinsky states that the Bobby then stepped in front of his vehicle. Just look at it. This is a very, very important thing. In front of his vehicle in an attempt to stop him from leaving the property. He further states that his headlights were shining directly on Mr. Daisy at this point. Such a detailed account. Okay. Mr. Sovinsky then states that he came within 5 feet of Bobby Daisy, who looked unhappy to see him on the road, and he was forced to swerve into a ditch to avoid him. Fearing for his safety, Mr. Sovinsky was scared because after all, you're seeing this person, this boy in front of the vehicle. He could understand that he was definitely trying to hide something. Mr. Sovinsky is called out, "Paper boy, got to go." Think about it. So detailed. He has even mentioned exactly what he has stated. Okay, such a detailed version of facts. And drove towards the exit. After leaving that, Mrs. Hallback's car was found in the property. Mr. Sovinsky states that he realized the importance of what he had seen and immediately contacted the Manitowick County Sheriff's Department to report the encounter. Mr. Sovinsky then states that after viewing the television show Making of a Murderer, he contacted the Innocence Project in New York to report the incident again. Finally, in 2020, Mr. Sovinsky contacted the defense current counsel and the current affidavit was drafted. So, as you know, I have told you with respect to the first two tests, it has satisfied the Edmonds test which has been used in this case. There has been two tests which have been used with respect to two cases. One is the Edmonds test and one is the Denny test. The Denny test is not a test which should be applied in a case like this because we do have a state player, in my opinion, and even if we do explore it closely, I would say to a certain extent it does satisfy the requirements there also. Regarding the Edmonds test, that is a much better test to apply in this motion for retrial, and I'm talking it principally from the angle of law and justice, right? Edmonds test is a much better test to apply in case an innocent man is in jail and he needs his trial needs to happen so that the evidence, the newly discovered evidence, can be verified or tested. The judge has actually taken down all the 4 standards, accepted the 2 standards have been correctly applied, but for the last 2 standards, what she did was that she went ahead and took the help of Denny test. You can't do that. if you go ahead and apply the principles of law with respect to a case, to a situation, you need to do it in toto with respect to that case and that situation. You cannot go ahead and take two tests and say, okay, this satisfies, this situation gets satisfied by these two tests, but for the third test I will take the help of Denny test. That vitiates the whole process. You should take the test as it is, the principle of test as it is, and apply it here. And in this case, if you apply the test, what it essentially denotes is that once all these things are satisfied, a reasonable probability exists that basically if these requirements are met, the circuit court is required to determine whether a reasonable probability exists that a different result would be reached in a new trial. And in this case, it would most definitely have reached a different outcome, because if the jury came to know that Bobby Daisy was pushing a blue RAV4 on 5th November morning with an older man whom Sovinsky has identified was not Avery, then they will think twice about Bobby Daisy's testimony that he was the last person who saw Steven Avery with the victim. They will think that maybe there is some motive of his to actually go ahead and say these things. Secondly, if they are supposed to be in the car, pushing that car and pushing it to a designated spot where finally the search party discovers the car, it goes to show that Bobby Daisy was in possession of the car. So there is a different narrative than the one which was presented by Kratz to prove Steven Avery's guilt. So, based on that, definitely reasonable doubt can be generated in the minds of the jury, and that should be examined, and for that a new retrial should happen, especially an evidentiary hearing which goes to the credibility of Sovinsky, which did not happen here, and all these principles of law and everything was derailed by this county judge. So I just hope the appeals court goes ahead and rules properly. In my second video, you will find out how I go ahead and explain the last two principles or the last two standards of the Edmund test, which was not applied in this case, and you will be startled that those principles, if they were applied, then Steven Avery would have got a retrial immediately. Anyways, better late than never. I can always say justice can get delayed, but justice will never get denied. I have complete faith in the American judicial system that they will eventually pronounce Steven Avery not guilty and set him free. My only problem is I feel now we can understand or feel that probably we know who has actually killed Teresa Hallback, but we can't do anything about it. Because one of the major clinching evidence which could have been used to prove even the real killer's crime beyond reasonable doubt, that bone pile evidence, you can check my other videos, that has been returned to the family, and we are not sure whether that has been cremated or buried. We have no idea where it is, and that is very important, those extra bone pile evidence which was found in the Manitoba County query. Anyways, watch my second video, and thanks for listening to me. Hope I've been able to make you all understand some of the principles of law and how it has been misapplied in this case. That's why I just analyzed it. All power to Steven Avery, all power to Kathleen Zellner. Don't lose hope. As I told you, justice can get delayed, but it shouldn't be denied. So let's hope for the best for Steven. Bye. Take care. Watch my second part also of this video. Thank you. Bye.